Good, whatever this is, which I guess is what I always say now. Like, subscribe, share, not legal advice. Please don't rely upon anything I say. Hope all is well. Hope everybody is well. Hope this is helpful. Tonight, I wanted to talk a little bit about the South Korean anti short movement, uh, legal headlines regarding Tesla and jurkesy, and arbitration, and something about that also. But before I get started, of course, I wanted to address a couple things. Did you hear about the Italian chef who died? He just passed away. What is red and is bad for your teeth? A brick. And last but not least, what do you call an alligator in a vest? An investigator. Anyway, I hope those jokes help you. I hope those are jokes. Show this to your plants because they love those jokes, especially the animal jokes. Just so we're clear. Anyway, I wanted to talk about the three things I mentioned. So, first thing I want to talk about was the South Korean market and Thai anti-short campaign. So they've banned short selling in South Korea, and I think they're intending to in Thai, at least for a limited period of time. Although I've also heard it discussed they may extend it beyond, I think it was June when they were going to discontinue the ban. But what's interesting to me is going to those markets to assist in helping them with their short sale ban. Our representative are our regulators who can't even regulate our own markets. What are their intentions when they're going to South Korea? Is it to assist or to hinder? I don't have a lot of confidence that our regulators are really there to do good. So I would urge the South Korean regulators to be on their guard, not to be negatively influenced by uh, data and content by our regulators, because they don't seem to be doing the job. Certainly, as to short sells, of course, you could look at it another way that they're experts in short sales because they let it and permit it to occur and must be aware of it. So, but anyway, I'm cautious when I hear our regulators are going to help other marketplaces when they can't even regulate our own markets. So that's number one. Legal headlines. Legal headlines. Why can't they be trusted? I've said that before, and I just wanted to give a couple examples, recent examples of legal headlines and why I thought they were inaccurate. And obviously, I follow Tesla and Elon Musk. Tesla just came out with a Cybertruck, was just delivered. And if you happen to watch the delivery event or a video, pull up a Tesla, the Cybertruck racing against a Porsche Carrera. It was very interesting. So they had on a track a new Cybertruck racing a Porsche Carrera, and Tesla easily won. And at the end, you see that the Cybertruck, while beating the Porsche Carrera, is towing a Porsche Carrera too. So I found it interesting. But anyway, about a week ago, I saw a couple of articles in about a case. Tesla's in a lot of litigation. So those articles catch my attention. And I saw two headlines. I'm going to read you the headlines because they're quick. Judge says evidence shows Tesla and Elon Musk knew about flawed autopilot system. That's one headline. The other headline is Tesla faces potential punitive damages as judge finds reasonable evidence of autopilot defect awareness. So that's about the same story. And from that headline, you would think that a court has made a decision about a factual issue that Tesla knew about a defect in the autopilot system. But if you read further and you could discern what they were trying to state, they were talking about a motion for summary judgment. So let me reiterate what a motion for summary judgment is. So when you file a case, you file a complaint, the other side files an answer, then you do discovery, and then you have a trial date set. But before you get to trial, if the facts are not in dispute, you can file something called a motion for summary judgment. With that, the court not having to decide a factual issue, can just rule on the law and make a decision. And the court can issue a judgment without there being a trial. And that is a perfectly legitimate proceeding. But they're uh, very critical in terms of finding if there is a factual issue. So if there's any way that a factual issue can be found, that is sufficient for the court to deny the summary judgment motion. For example, again, if we're talking about an accident and I said the car crossed and there was a red light, and someone else said a car crossed and there was a green light. So there would be a dispute of fact as to the color of the light that might be impactful on the decision as to who was at fault in a car accident. So because there was a dispute of fact, the court cannot grant a summary judgment. So those headlines suggested that the court had already made a determination. All the court had made was a determination that there was a question of fact as to whether Tesla or Elon Musk was on notice as to a particular defect. There hasn't been a finding, by the way, that there was a defect also, but there was a finding that there was an issue of fact. So somebody might have said that we didn't know, and the court and somebody else might have argued they did based upon this, and the court very well may say that creates an issue of fact. That doesn't mean that once you go to trial that will be established. It just means at this point in time there is a dispute as to a fact, not that a fact has been established as the headline suggests. So be alert when you see those headlines, because this, I think, is an inaccurate headline that impacts Tesla. Went by. I don't think it dramatically impacted, but it's an inaccurate headline and suggests a conclusion that is not true. So that's as to Tesla. On top of that, there's another headline regarding jurkesy, and Brian and I, JR and I, did a couple of live streams. I think I did a video about the jurkesy case, and I looked at a headline involving that case. The headline I'm going to read says U.S. Supreme Court signals it could limit SEC in-house enforcement. And I don't think that's an accurate reading of the case either. This was put out after the oral argument. And if you go back and listen to JR and I, our live stream, before we even heard the second half of the argument, our headline would have been different. It's not that the U.S. Supreme Court signals a limit to SEC in-house enforcement. It suggested that where there is monetary relief sought or a fraud claim, that those type of cases might be more apt for federal court, not a broad, complete limitation on SEC in-house enforcement. As a matter of fact, and I think a video I did said this, it appears that the Supreme Court is going to be removing powers of the regulators, including the SEC, maybe FINRA, one pedal at a time, not grossly. So they may limit, for example, that claims involving monetary damages have to go to federal court, or claims involving fraud claims have to go to federal court, but not that the SEC has no enforcement powers. So I found the headline, again, to be super broad and overly broad. So beware when you see legal headlines to understand the accuracy of them and to be skeptical of their legality and accuracy, let's say. Last but not least, as I have said, I'm going to, as we go on, keep you updated in terms of my MMTLP arbitration. And as I also indicated, I believe, I've had a conversation with somebody else who is involved in an arbitration, and he actually filed his arbitration after he learned that I filed mine. He's a lawyer also in a different jurisdiction. He's also fighting discovery. I think I've mentioned that I've requested a bunch of discovery, but there's some discovery that's presumptive that each party should exchanged with the other party absent a good excuse. And he's involved, the other gentleman who's in the arbitration is involved in discovery disputes, different broker. We're cooperating, and we'll try to help each other and anybody else who will be in arbitration. But I wanted to kind of go over what documents that, without you asking for them, if you engage in arbitration without an answer, what does the broker have to provide you? What categories of documents? The account record and your account record and information, and all agreements you have with the broker, all correspondence they've sent to you relating to claims, accounts, transactions, etc., all documents evidencing any investment or trading strategies utilized or recommended in your account, all materials that the firm has sent to you. And by the way, I'll continue this on, but there is an actual document. So if you look at the FINRA Discovery Guide, that's what you would look for. So if you went to Google and you Googled FINRA Discovery Guide, it would pull out an item. I think the last one is 2013. You could pull it up and you will see what I'm saying now in form. So you don't have to write these down, but I'm just kind of giving you an idea of what documents they should be producing, just as a matter of course, absent, again, a good reason. All notes made relating to the customer parties, claims, accounts, all the reviews, all correspondence, all recordings, telephone logs, and notes of telephone conversations, all writings reflecting written communications involving your account, all forms, RE3, U4, and U5, and disclosure reporting pages, all sections for all of the firm's manuals and updates relating to claims alleged in the statement of claim for all years in which the statement of claim alleged that the conduct occurred, all analysis and reconciliation of customer party accounts, which would be interesting because would that relate to the MMTLP situation? Should there be a reconciliation per the discovery guide? All exception reports, activity reports for claims, internal audit reports for the branch in which the customer party's accounts are maintained, records of disciplinary action taken by associated parties, all investigation charges or findings by any regulator regarding charges or findings for the associated persons if it involved a particular person as opposed to just a brokerage, examination reports, all documents related to the case at issue to the firm's persons received by subpoena, all claim documents, personnel information, commission information, compensation information, etc. So there's a large number and variety of documents that I'm expecting the Fidelity to produce. They've produced a very minimal number of documents. They've provided a confidentiality and protective order, which I've signed to get additional documents, and we'll see where it goes. But I just wanted you to understand that if you brought an arbitration, notwithstanding you having to ask for documents, there's 22 categories of documents that are listed that they should be producing or giving you responses as to why they're not producing, and that information is available to you, as are the rules. So that goes over the categories of documents just generally that they have to produce, and you can look it up yourself so you don't have to remember it. And as I indicated, as time goes on, we will start dealing with all the rules of arbitration, and at least the major ones, to try to explain those and how they apply, in addition to what we just referenced in terms of document production. Anyway, so those are the things I wanted to address today. Hope you're well. JR and I are doing a live stream tomorrow, 6:45 p.m. Sunday night, YouTube. We'll address a bunch of other stuff and hopefully as high quality jokes. Anyway, hope you're all well. Hope this was helpful. If you have questions, please comment with any questions. Happy to answer if anybody's confused as to any of the stuff I mentioned tonight. Be well. Have a great weekend. Take care. See you for Sunday night.